Hi, I'm Jonathan Hafetz, and welcome to Law on Film, a podcast that examines law through film and film through law. This episode, we look at Erin Brockovich, the 2000 film directed by Steven Soderbergh that's based on a true story of Erin Brockovich, a legal assistant without formal training who helps bring one of the most significant environmental lawsuits in U.S. history, the case against Pacific Gas and Electric for contaminating groundwater in Hinkley, California. The film, which features an Oscar-winning performance by Julia Roberts in the title role, explores the role of lawsuits in exposing the truth and gaining compensation for victims, the obstacles those lawsuits face, and the gendered dynamics of legal advocacy as well. Joining me to talk about Erin Brockovich is Dror Ladin. Dror is senior attorney at Earthjustice's Northeast Regional Office, where he focuses on enforcing climate mandates. He's also representing Riders Alliance to ensure that New York can have congestion pricing and to prevent the federal government from eradicating it. Dror was previously an attorney at the American Civil Liberties Union, where he represented the Sierra Club and the Southern Border Communities Coalition in their challenge to President Trump's border wall. He also worked on numerous cases seeking to enforce constitutional protections and human rights in areas like torture and arbitrary detention. I was proud to work alongside Dror in many of these challenges, fighting the very difficult battle against the U.S. government. Sometimes felt like tilting at windmills. Dror, it's great to have you on Law on Film, and I'm looking forward to talking about this movie.
Great to be here.
So the film centers on this mass tort litigation. What's the basic background for the case, and how did they learn about it?
So the film describes, in sort of an abbreviated fashion, how Erin Brockovich, who is in the beginning sort of a file clerk, but rapidly develops into, probably the most formidable paralegal or non-lawyer on a legal team that maybe has ever been depicted. She, in the course of looking at what appears to be a simple pro bono real estate transaction in which Pacific Gas and Electric is seeking to purchase a home in Hinkley, California, she discovers that the people whose home is being purchased seem to have a huge array of health problems that might be caused by contamination coming from PG&E, and that in fact all these real estate transactions that the utility has been conducting in Hinkley, California, might actually be a way of trying to cover up the environmental damage it has inflicted on the community. And so she's very dogged. She uncovers all kinds of very incriminating documents from the water board, and she basically pieces together both the source of the contamination from the PG&E plant to the specific health problems that are devastating the community in Hinkley.
So she's not a lawyer, but she has all these other set of skills to try to gather this information. I mean, why is it so hard sometimes to get this kind of information that Erin Brockovich is able to finally get?
I think, there's there's a lot of reasons. So first of all, one of the main impediments to anyone who's trying to bring some kind of lawsuit for accountability is often the person who knows what really happened and holds the documents to prove them is the person you're suing. It's the entity. So here, PG&E had all kinds of documents about its own culpability, but it had, as later described in the movie, actually sought to destroy a lot of those documents, and other documents were sort of buried in these bureaucratic files in the county water board that were very inaccessible to ordinary members of the public. And the movie describes a very wily Erin Brockovich sort of using her charm and savvy to get past, maybe not the most impressive bureaucratic employee of all time, and just let herself into a back room where she can conduct explorations of what exactly, the paper trail she's looking at is all kinds of documents that date back decades before she's looking at them. So there are, all these water test results and orders from the 60s, because the discharge, one of the things that the movie sort of shows very well is how historical problems with the environment have, repercussions that last well beyond, when they occurred. So all this actually occurred due to a chromium discharge that happened, I think, between, the 50s and the 60s. And its health problems are manifesting in the 80s and 90s. And she uncovers all these documents. But she does it, in the movie, it's really portrayed through just she talks to professors, she uncovers documents, she talks to everyone, she talks to people in the community, she sort of assembles a history. It shows really the importance of this kind of person-to-person investigation, which is not in any way dissimilar, I think, to what an investigative journalist does or to what other kinds of investigators do. And John, I know you and I have been on cases where we've had investigators, and then we've also had lawyers who act like investigators or paralegals who act like investigators. all this investigation is so that you can actually get into court to begin with, because you never have access to begin with to the other side's documents. That only comes much later.
One of the other obstacles, or sort of, kind of implicit what you're saying, is beyond getting the information that the other side controls, is you're dealing with people who've suffered, trauma, in this case, terrible health effects, right? Their children, themselves. So you've, in your environmental work and your work representing like torture victims, that's like another dynamic, right? So she's sort of does both. She's dogged and getting the information, I guess, but she's also able to sort of talk sympathetically to people.
Yeah, and that's such a huge part of both her skill set and so essential to this case, or really any case working. And the movie almost caricatures it. There's a character of this incredibly buttoned up lawyer who's sort of has like a helmet of hair, and it's like visibly uncomfortable talking to ordinary human beings outside the confines of like a law firm conference room. So she goes in the community, immediately alienates everyone she talks to, and it's just the exact opposite of Erin Brockovich's approach. And that's one that especially when cases are extremely difficult, just like you said, when they deal with trauma, when they deal with people really suffering, the worst thing that is imaginable to them. There's so many ways in which it can go wrong to try to translate that suffering into the language of the law, because you see this lawyer sort of engaging in classic mistakes where she she like immediately tells them when they start talking to her, rather than sort of being open to hearing from another human being. She tells them, please, keep your emotional story to the side. Don't, please, give it to me in the driest possible terms. That's not a way in which any ordinary human being relates. And especially when you're asking people to open up and trust you with something that is so difficult for them, it's just such a different skill set to be able to elicit that and be compassionate about it. And you and I have had, of course, the great fortune of working with an acknowledged great at this, which is Stephen Watt, who is a colleague of ours who unbelievably is actually a lawyer, because there's the movie suggests that lawyers don't have this touch, but Stephen is exceptional in many ways. And we worked with Stephen on a lot of cases involving people who had suffered really grotesque and horrifying abuses by powerful figures, and by powerful figures who would abuse them and ask them questions, and abuse them and ask them questions. And that can map on so easily to the dynamic of a lawyer-client, interview. And so you really need just an unbelievable level of sensitivity and interhuman intelligence and kindness to deal with that. And, as this movie really aptly demonstrates, if you don't have that, it's just impossible to have any kind of client relationship in this kind of case.
Yeah, it really makes that point. I mean, yeah, it's kind of very, very dramatic black and white terms, but it kind of does bring it out. I mean, so one of the advantages, or one of the challenges in bringing this type of mass tort litigation against anyone, and especially as a large company, is that they have the information, right? You don't know what they know, and there's asymmetrical access to information. I mean, the movie also sort of suggests there's other obstacles in terms of imbalance of wealth and power.
Yeah, I mean, this is something that the movie shows extremely well in that meeting. So that what's happening is later on in the film, they've moved past this sort of initial obstacle of even establishing that they have a case. So in the movie, it's because it's state court, it's a demur. In the context that you and I practice in more frequently, it's a motion to dismiss. But basically, there's this initial part of the case where you have to actually establish that you have a case. You get beyond that, you can get to start proving your case, establishing your case, all the appeals, all the endless procedural motions, discovery, all this stuff that basically ties up civil litigation for frequently years and years and years. And rather than attempt to do that in the course of sort of ordinary civil litigation, there's this proposal by a mass tort expert who's brought in to join this sort of small law firm that Erin Brockovich works for. He suggests that instead of sort of going through the normal trial procedures, they submit to a binding arbitration, in which case they will just not have a jury, they won't have a full trial, and there won't be any appeal. So both sides will have to accept the verdict, which will provide, a limitation on the timeline of the whole thing. And why would, a defendant agree to this? Well, the reason a defendant agrees to it in this case is because PG&E is able to cap their liability. They know going into this binding arbitration, they will not pay more than $400 million, no matter what is established. And so that is something that then Erin Brockovich and the main lawyer in the case have to take to the community and explain to them why they're willing to, or why they're recommending that the members of the community basically sign away their right to go to court, to appeal, to have, an unlimited trial. and instead to just basically bargain, or not really bargain, but submit to, this one arbitrator will decide a number for them and with a cap on what that number might be. And, initially the people of the town they're very put off by this. They're very taken aback. It seems very unnatural. They've had these lawyers tell them all along, it's going to be a struggle, but we're here for you. And at the end of the day, we think your case is very strong and you'll get to tell your story in a courtroom and you'll get all this money. And they have to give them, the lawyers have to give them, unfortunately, a reality check about sort of the way in which American law operates, which is if you are a large corporation or if you're the United States government, you can often put off any obligation to pay, even in an open and shut case, for a very, very long time. This is something that you can see, Donald Trump using both in his personal litigation strategy and his government doing, where whenever they get orders against them, they seek to forestall those orders, they seek to appeal those orders quickly, they seek to defer any obligation to pay. And the result is that people who are much smaller entities, people who are not the government, who are not giant multi-billion-dollar corporations, can't really wait it out, even if they are ultimately going to win. If at the end of the day, for them, often it's much more realistic and much more beneficial to their present circumstances to accept a much lesser payment today than what they would actually be entitled to, once all the stalling tactics were defeated, which could be 10 years or more. There's a very powerful sort of analogy that the lawyer gives during this meeting where he says, have you all heard of the Love Canal? That was, they established liability at the end of the 70s, and people were still waiting for their payouts at the time of the Erin Brockovich movie, which is taking place in the early 90s. So, that's not at all unheard of for these things to take years and years and years. And when you've got health problems, when you've got, family members who need the money, when you need the money, it's often not realistic to ask people to wait. And I've certainly been involved in lawsuits where that was a real hard question for the plaintiffs in the lawsuit, was whether to accept a much lesser amount of money than they would probably receive at the end of a trial for the sake of actually getting it right now without further appeals taking more and more years off. And I've had clients go both ways. I've had people who decided they wanted to stick it out, and I've had people who said, this is as far as I want to go.
So it's delayed for the clients, and then they also brings out it's how hard it is to litigate the case for it's the law firm, right? It's a small or medium-ish size law firm that under Ed Masry, right, the Albert Finney character who runs a law firm, and he just keeps saying they'll just bury us in costs. We don't have the money to keep fighting, and they get into this also a little bit with the contingency figure that they get. I mean, they'll get, which seems like a lot, and they have to explain why it's not so much the 40%. But at the end, they're just, shelling out thousands of dollars, tens of thousands of dollars, $100,000, and PG&E is just, vastly outarms them.
Yeah, that's a great point. And I think Finney at one point his character is like getting a second mortgage on his house or something to keep the lawsuit going. So you're exactly right. Yeah, it's not just the clients who are facing this terrible choice between less money now and some kind of indefinite payday in the future. But yeah, the law firm is out all this money with actually no guarantee that they'll ever get, recoup a cent of it. And that can be extremely punishing for a small firm over time. I will confess that I've never worked for a small firm. I've always worked for nonprofit organizations where your incentives are a little different. But yeah, that that similar concern has also spun off, right, all these litigation finance innovations where now you have, the idea of a payday in the future is something that's very attractive to all kinds of, investors and alternative assets. So there's now all this, I've certainly gotten solicitations, in fact, which was very funny because when I was at the ACLU, I would get emails from litigation funders saying I see you're involved in this torts case. Would you like to talk to us about our litigation funding, package in which we would take some percentage of your future recovery and, in exchange for money now? And of course, that's not the kind of agreement the ACLU would ever get into, but they're hunting for verdicts.
I don't know that they would have taken our cases either when push comes.
Yeah.
And so you meant Hinkley. So this place, right, in California, we see a little bit about, we meet some of the people from Hinkley through the movie. There's some sort of background on, how this came to happen at Hinkley. Why do things like this happen in these kinds of places?
In our society, the way we organize it is often we have places that are very expensive to live in, and we have places that are less expensive to live in. And the places that are more expensive, are often protected by all kinds of zoning codes and very active residents, and just the fact that, land around them is expensive. And on the other hand, you have large swaths of the country where many people live, but where they don't have those similar protections. And that is where you end up with so much of this country's, industrial waste, basically. And whether it's, there was a natural gas pipeline that was flowing through Hinkley, and they had, I don't know if it's like a compressor station or what it was there that needed the cooling towers. But, the fact of the matter is, now that I deal a lot with communities in New York and some other places, but especially in New York, and it's often the same sort of communities that are exposed to power plants, as are exposed to water pollution, as are exposed to other kinds of facilities, as are exposed to like diesel trucks. You end up having these places that we call environmental justice communities, or sometimes, if they've been really overloaded with bad, toxic plants, you might call them sacrifice zones. They're areas in which we basically decided as a society, no one's made the like explicit decision to say Hinkley will be the place that suffers, so the rest of us can have power, or the rest of us can have plastics or whatever it is. But the fundamental result is there's all kinds of places in this country that are called, things like Cancer Alley, where you have people who live in communities that are just overloaded with all these industrial facilities that are not, that are not near the homes of the rest of us. And there's an effort, in recent years to try to address that through environmental justice laws that try to reduce the existing disproportionate burdens on these communities, because again, these communities are basically like carrying the load of a giant society that is just being concentrated in much fewer areas. But that's very hard to do because there's, a lot of political power that avoids a more equitable distribution. And we recently have seen the Trump administration try to just end any consideration of environmental justice and really aggressively go after attempts to improve that inequitable distribution. So it's not terribly surprising that the people of Hinkley, who are, a small remote town, were the ones who are made to endure this kind of pollution. The problem is, what are we doing right now, and how can we prevent, this kind of just sacrifice of a community? Because right now Hinkley is basically, I mean, there's very little left of it. It's not that it's now like a beach town of or a vacation town of people all living in their $5 million houses and whatever, using the proceeds from the Hinkley settlement. The town is really emptied out. There's fewer residents now than there were at the time of the movie, and the waste plume there is expanding. So it's really just just destroyed this community.
And so just to go back to one of the obstacles you were talking about in terms of accessing the records, right? So, one problem is like, the other side has the records, or they're difficult to get, and Erin Brockovich is able to find some of them. She also relies on, get some gifts from a whistleblower. I think in reality it was kind of a composite group of whistleblowers who hand over information. Are there any changes in terms of the record keeping that's going on? I mean, that just presupposes the records exist, but I mean, are there any developments in terms of how records are being kept? Because ultimately there are records that she gets.
Yeah. I mean, and the case really is a testament to the importance of having those records. Like the fact that someone wrote that down in the 60s is what creates the paper trail that allows for, allocation of responsibility today. Unfortunately, we're facing right now the most deregulatory EPA of all time. And so there's any number of pollutants that currently have to be kept track of, that are currently regulated. And regulated means you have to maintain records, you have to give records to the EPA. There's very basic ones on like greenhouse gas reporting requirements, that the climate crisis we're facing is one that, actually extends to almost every community in America in one way or another, in a way that's sort of different than other forms of pollution. And yet, just now, the EPA has ended, or is attempting to end, its reporting requirements on release of carbon dioxide. And so we're in this very strange situation in which we learn more and more every year about chemicals that are dangerous that we didn't know were dangerous. There's lots of litigation and efforts to try to get EPA to regulate more chemicals rather than less. There's few people, I think, who would say that the main problem that we face as a society is that PG&E was required to keep records about chromium. It was in fact essential that they keep those records. You don't usually say like we have too much record keeping about lead or something like that. But you do have a particular species of sort of deregulatory zealot who does believe that it is the government should not be in the business of asking for compliance with different kinds of restrictions. It should not be in the business of studying the health effects long-term of various kinds of chemicals and compounds, and that it's onerous to require people who run power plants or other kinds of facilities to keep records of what it is that they're putting out into the atmosphere, setting up monitoring equipment and things like that. And unfortunately, where we are right now is that this narrative has a lot of power. And so there is really an unprecedented level to stop keeping records on all kinds of things. And as to what that effect will be, I mean, for one thing, it's not just that it might impact the ability to bring lawsuits. It might make it very difficult to even understand why it is that particular things are happening. You stop keeping track of carbon, you have less of a sense of why it is that the climate is changing the way that it is. You stop keeping track of pollutants, you might not be able to track why it is that a certain group of people suddenly all have cancer in a particular community. And these kinds of things need to be studied. It's just mind-boggling to me that we would reduce the amount of information we have rather than increasing it.
Yeah, I mean, it would make it impossible to bring this. There were obstacles that like Erin Brockovich and the firm faced in terms of getting access, but they were there and ultimately they get them. But if they don't exist, that's really impossible. And the people themselves suggest they probably don't even know, right? I mean, it helps people figure out what's happening in the community. So it's kind of stunning. I mean, another thing that's going on now, right, is tort reform, right? This was made in 2000. So we're talking about 25 years ago. The case itself is from the mid-late 90s. So what's happened in terms of tort reform and limitations on plaintiffs to seek recovery?
Yeah. So there's a huge, again, like another narrative. And the whole question that gets raised in the movie about the importance of punitives and punitives is one that is sort of shorthand for this idea in the law that sometimes you have multiple kinds of damages that might be awarded to a person who has suffered, right? They can get what are called compensatory damages. So say, a person in Hinkley now is disabled due to, they talked about that man who had like a spine issue that deteriorated after exposure. So he might be disabled. So then the way the law would look at that ordinarily is the compensation for that would be his lost wages. If he no longer can work because of disability, it would be lost wages. Now, if you're working a low income job, lost wages might not be calculated to be that high. You're an older person. Maybe how many more, working years did you have? This is not like a giant sum for, especially, when you're a multi-billion-dollar corporation that has to pay it. The same thing is true even when it comes to human suffering. I mean, we try to quantify, like the cost of medical care, the levels of distress and pain and suffering, but the law is not incredibly generous about putting numbers on those. The idea is that the law should also form some kind of deterrence to a bad actor. If you're a multi-billion-dollar corporation and you have to just pay for a few people's wages, a few hundred people's wages and some of their medical bills, that's not necessarily such a big expense for you. So there's some idea that you want to deter it. You want to make the corporation really take notice. And also, there's just an idea that as a society, we want to send some kind of message here. We want to say, this is really bad. You poisoned the whole community and then lied about it. That's a terrible thing. And we want to make sure that, no one thinks of just ordering someone to go and destroy the records and not inform the neighbors and do all this stuff again. And so that's where punitive damages come in, and they can be enormous and they can seem disproportionate to the harm because of how little value, the law places on things like human life and jobs. And so, you can have the idea behind a punitive damage is if you prove that there was this reprehensible conduct, like they were able to establish here when they showed that PG&E knew about it and didn't inform anyone, that they can have sort of this like uncapped damage that attaches, that you're not required to prove, I have suffered X amount and try to quantify it. You instead say, what is a sum that expresses our outrage? What is a sum that shows the corporation this is not okay? This is not something that we allow in a civil context, because right, this isn't the criminal law punishing it. It's the civil context. It's the jury is punishing. And so those are multi-million-dollar verdicts, right, that we're talking about usually. And here, I assume, I don't know how the $300 million verdict broke down, but I assume some significant portion of it was punitive damages, since that was the ball game in many ways. Since this movie came out, there's been this chorus of outrage from the corporate sector saying, well, how can we plan, if we have this kind of like uncapped liability, if we don't know if some jury is going to say you spilled hot coffee on your lap and we're outraged at McDonald's for that, and so here's $3 million for every time you spill coffee. I mentioned the coffee lap thing because I think that was like really the face of tort reform for a while. So the Supreme Court has, in the 90s, it kind of refused to impose real restrictions on it. Basically just said you couldn't impose punitive damages based on harms that happened to people who weren't present in the lawsuit. So like if one person in Hinkley sues and says, but the punitive should be about what happened to everyone else in Hinkley, that would have been unacceptable under the due process clause, basically. But in the 2000s, there's been this steady march of decisions in which the Supreme Court actually decided that it didn't want corporations to, be assessed all that much punitive damages. And so the Supreme Court discovered this principle of proportionality, which had never really applied to the civil context in American jurisprudence. There was an excessive fines clause, and there's a cruel and unusual punishment clause that the court has opined on occasionally in terms of restricting the state's ability to punish people. But in terms of damages that a jury was awarding in a civil context, there was no similar principle. And so the court created one, and it has said, it should be a low multiplier. So you're not talking about like millions of dollars if your damages, your compensatory damages were just in the tens of thousands. And then, in one case, it even suggested the multiple should just be one. And, it's fascinating to see the Supreme Court so sort of engaged with the question of proportionality and so affronted at the idea that juries might overpunish a corporate defendant in this context, when the court is otherwise very untroubled by the concept of proportionality. So there have been other proportionality issues. Proportionality is a concept that's very familiar in international law. It's not very familiar in U.S. law, but it's something that's used all the time outside of the U.S. system to try to decide things like, should you send someone to jail for 30 years for a very minor crime? That's something that, other systems will examine proportionality. Here, we just have the cruel and unusual punishment clause, and the Supreme Court has basically said, they've looked at, for example, California's three strikes law and said there's no need to assess the proportionality of, a person going to jail for life for stealing videotapes. It's sufficient that the state made the connection and thought that was okay. Similarly, there's no proportionality requirement if you deport someone for committing an incredibly minor crime, right? You have someone who's like a long-term green card holder, they jump a turnstile twice, and then they get deported under immigration law. The court does not subject that to some kind of proportionality analysis, although, some advocates have tried that. So it is just another example of the way in which we seem to have a Supreme Court who's much more concerned about certain kinds of harms, certain, kinds of disproportionality than others.
And where do states figure in this, right? So California, now is a very forward-looking, progressive state on environmental regulation. And there was, I think, some state regulation even in the time of Erin Brockovich, going back even, to, in the 70s, 80s, 90s. Where does state regulation sort of fit in? Where to fit in Erin Brockovich? It's not really mentioned in the movie. You just have the private plaintiffs and you have PG&E. Where are states involved at all?
Yeah, I mean, there's a real push and pull. I mean, there's different states that have different regimes, but there is, I mean, like you say, it's a lot of times, this was even like a local water board, I think, that was doing the regulation, that was charged with keeping the water safe and demanding, a plan to clean up the water if it wasn't safe. And there are plenty of states that have, rigorous standards for testing, for all kinds of ways in which they keep their residents safe. I think one thing that's sort of interesting is the cleanup. So, like the Love Canal, which they mentioned in the movie, or other kinds of toxic sites, often, what you have is some area that's very expensive to clean up afterwards, and no one who's left holding the bag to clean it up, because the company that put these toxic materials in the ground, it's not always PG&E, which is like an enormous utility that did just actually declare bankruptcy based on its responsibility for the Dixie Fire, which was a giant wildfire in California that was caused by PG&E equipment. But often you have, just like these, small factories that existed in the 60s and 70s discharged some horrible chemical into the groundwater or the soil around them, did it in some slapdash fashion. And now, there's no legal entity there that is holding the bag. Someone else owns the property. So there are questions of, who has to pay to do cleanup. And that's something that is decided both at a federal level and at the state level. One interesting kind of law that the states are experimenting with right now is climate harms, right? So climate harms are similar in that, the discharges happen over years and then climate change happens, right? We have, the world warms based on decades and decades and decades of carbon that's emitted. For when it comes to hazardous materials, for certain hazardous materials, we have what's called the Superfund law, which creates this regime in which you find the bad actors basically, and you try to make them pay to clean up sites. It's not a punitive law, but it's a way to try to make sure that the state doesn't bear the entire burden. Taxpayers don't bear the entire burden of cleaning up their community if someone polluted it. And so it creates sort of like this strict liability for anyone in the chain who profited from a particular site or owned a particular site. On climate, we have nothing similar, right? So we have particular companies that are very responsible for climate change because they did things like extract lots and lots and lots and lots of coal and then burn it, and at the same time cover up, what they knew about the climate effects of it. But we don't really have any kind of regime to make sure that when we have to do adaptation for flooding, or when we have to, deal with erosion, or when we have to deal with, frankly, with installing, more temperate like building structures, like roofs that are white, or things that allow for better air conditioning in places that are getting hotter and hotter. We don't really have any sort of structure to do anything except to make taxpayers or individual homeowners or farmers or whomever responsible for the climate harms they endure. So a couple of states have tried passing what are called climate superfund laws. So New York and Vermont have passed the first of those, and there's efforts to pass them in other jurisdictions. And they basically set up this situation, which the state has said, we're not going to leave it up to, individual plaintiffs to try to file a lawsuit. We're not going to say like the farmers in the Catskills need to file a lawsuit saying we now have to spend twice as much on getting our fields, to bear fruit because of the fact that climate change has so altered the weather patterns, or because, the river is now flooding all the time and we now need to build up all these levees or things like that. Instead, at a state level, what we're going to do is we're going to levy a charge to the biggest polluters, the biggest, entities who are most responsible for emitting carbon, which is easily ascertainable, and we will charge them and use that money to fund the climate adaptation that our state has to undergo. And I mentioned this specifically because I've been involved with several lawsuits where, New York and Vermont have just started these plans. None of them has come into effect yet. They were just passed in recent years, but they've already been challenged by all the red states who charge that this interferes with interstate commerce. They've been, coal companies and the gas industry and the Chamber of Commerce have sued the states to say that they're not allowed to do it and that it's unconstitutional, unpreempted. And finally, the Trump administration has sued New York and Vermont as well, saying, how dare you try to assess levies on the basis of climate change? That's something that we've decided not to do, and we don't want you to do. So the question of how states can actually get involved in sort of remediating the harms that the corporations cause, and how we don't just leave it to like individual people to sue those corporations, but try to have the states come in and pass some legislation that reduces some of the local burden, is a really live one. And it's one that brings in questions about preemption, brings in questions about whether we have, different schemes in different states, whether the federal government can just keep everyone from doing it. There's a lot of unresolved questions there.
And I guess you don't have to also prove direct causation in the same way, or you just basically, because if they're the larger emitter or polluter, without tying it to a specific site, or is that not the...
Yeah, that's a really important question. So there's what's called attribution science, which is a way in which climate scientists assign, the relative responsibility for particular events. Like you have a year in which, like almost every year these days, right, in which you break the heat records that were broken the previous year. You have, more destructive hurricanes. You have all these things that would appear to be the result of climate change. At the same time, if you were like, there have been cases in which people were harmed by, a particular hurricane and then tried to sue a particular fuel company or set of fuel companies saying, because you caused climate change, this happened and damaged me in X way. A lot of those cases are still out there and untested, but that's a hard theory of causation because of just the global nature of climate change. At the same time, the science is progressing. So my understanding is that there is ways to attribute specific climate harms to specific emitters. But this is almost, because again, this is not being done through a tort model or through some kind of punishment model, but it's done through like a superfund model. The idea is to get away from that kind of specific traceability of like, and the idea is, look, it is unquestionable that New York has to spend hundreds of millions of dollars to adapt to climate change. It's not just New York. I mean, other states do too. But, for us specifically, it's things like flooding. That's how it manifests a lot in New York. And that's really expensive too. We're not talking about remediating past floods. We're talking about adapting to the floods that are sure to come in the future because of climate change. That kind of adaptation costs a lot of money. At the same time, it is also undisputed who the largest emitters of carbon are. And so I think the traceability there is easier. There's still, scientific proof that establishes, that say the biggest coal company was responsible for a particular share of overall climate change, which then result in, specific climate harm scattered throughout. But here it's less, because you're not seeking, again, to remediate a specific thing you're trying to prove damages on. You're instead setting up a fund for adaptation. It works much more like remediation, and therefore I think doesn't develop the same problems of proof that you would have in a private tort action.
So interesting. I guess you got to think about how to make a movie about that, right? I mean, you get the Erin Brockovich is very like you get the David and Goliath story, right, about in sort of private tort reform. But I guess I mean, certain ways, like it's not really like it's great for the particular case, and there was deterrent value for PG&E, and the victims were compensated. It was terrible, pollution they had to suffer. But private tort litigation, while important and shouldn't be cut off, is not ultimately probably the most effective way to deal with environmental protection.
Yeah, yeah. I mean, in many ways, like it's like the same way that we have like, all kinds of, I mean, we look to torts to solve all kinds of problems we have as a society, unfortunately. And it is, it's tragic because we don't take care, right? It's like the people of Hinkley, if they weren't able to pin it on, I mean, it was PG&E's fault, but if they weren't able to pin it on like the larger PG&E, they wouldn't even have had the money that they needed to deal with their own health problems, right? There's like that whole thing about whether they can connect it to San Francisco PG&E or whether they're stuck with Hinkley PG&E. And that happens so often, right? Where people are really harmed, but the defendant is judgment proof. And so they can't get, the money from the defendant, or they can't connect it to the deeper pocketed defendant. And as a society, we don't have like some kind of backstop that says like, well, we're not just going to let you suffer with cancer, or I'm just going to let like actually that's how our society works. It's like unless you manage to bring it, in the language of tort, through this like fully capitalist allocation of money, you're just shit out of luck. And so yeah, I mean the story is obviously one that it's very like inspiring, and you watch it and you think like maybe things are okay. But it's really actually illustrative of a much larger problem that very rarely plays out in the way that it played out in Hinkley. And Erin Brockovich's subsequent career is one in which she did a lot of consultations on other sort of mass torts, one of which is previewed at the end of the movie, which was another sort of like, it was very similar in that it was another chromium against PG&E from a different community, I think along the same natural gas pipeline. But she also did, consulted to all kinds of people suffering other kinds of toxic torts. And unfortunately, it's not that most of the time it lines up so neatly where you have the ability to really hold someone accountable and get meaningful justice. And that's true both in the in the toxic tort context, and also as you and I know, it's very true in people who are harmed by the government.
Yeah, for sure. In the civil rights context, certainly in the national security context. Yeah, I mean, we see that now. I mean, for all the things that are going on under the current Trump administration, there's not going to be, virtually any form of any form of liability for the constitutional torts. I mean, even Erin Brockovich, I just go back on that point you're making about they have to trace to PG&E in the deep pockets, right? Which is also like in a civil action, which took place in Massachusetts, same thing, right? They've got to tie it to the deep pockets. And it kind of depends. Like ultimately, what really unlocks the door is the whistleblower, right? There's this person she meets in a bar. Erin Brockovich meets in a bar. She thinks he's kind of coming on to her, but he's not. He's actually, got this information. He's kind of been watching and waiting to see. And I think in reality, it wasn't one person, it was multiple people. But I guess, like what role does like the whistleblower play in these environmental cases? How important are they? They seem so critical in this case.
The whole question of assigning liability and connecting it to the mothership is one that's really important. Leaving aside the environmental context, it's one that's extremely important in, for example, the Alien Tort Statute context, where the idea is often, again, we were totally departing because oftentimes the worst abuses that the Alien Tort Statute addresses take place overseas. And for a lot of years, that wasn't a problem because the idea was the Alien Tort Statute was supposed to cover, I mean, A, it covers aliens, which generally are often people who are not located in the US. But B, it was intended really to deal with these terrible crimes like piracy, which always take place outside of the US, right? The whole idea behind them was to take place, there were interferences that were happening on the seas. And over the years, the Supreme Court has tried to narrow the idea of liability accruing to US-based entities based on conduct that the same company undertook outside of the US. And so now there's just this whole question in all these ATS cases, whether it's about, Nestle using child slavery, or whether it's about Chevron, hiring thugs to beat up, organizers, all these things that are acknowledged, to have happened by the company's subsidiaries, just like here was like by PG&E's, like Hinkley's subsidiary. And the question is whether the mothership is involved, whether there's like a nexus to the mothership's bad action. And outside of whistleblowing, it really is just so difficult to know that kind of internal, like you can absolutely know about the abuse where it happened, but to be able to know the chain of internal stuff that happened at the company, that's impossible without insight into the company. And so if you set that up as a requirement, and you can't even bring the lawsuit unless you already can establish knowledge of what happened inside the company that led to that outcome, That's just an impossible threshold to meet. Again, absent a whistleblower. I mean, for us in the Mitchell and Jessen case that we did about a CIA contractor here, there were all these questions about what conduct had they, the torture happened overseas. The CIA prisons were overseas. So the question is, what was the US based conduct that happened? And for us, we didn't have quite the same type of whistleblower. What we had was the Senate report on torture, which declassified a lot of the documents that happened internally that we would not have had access to otherwise. And those established the existence of meetings, the fact, I mean, for us, it was really critical that the torture techniques themselves were proposed on continental United States before they were deployed outside the United States. That became very essential for these extraterritoriality questions. So yeah, I mean, whistleblowers, government reports, I mean, the whole gutting of our inspectors general, like in the CIA context, that was where a lot of this came out, was these inspector general reports from 2004. If you gut all these offices, inside the government, and if you don't set up any reporting requirements outside of the government, then everyone's in the dark. And it really, like, you can know that a harm happened, but it's absolutely impossible to pin it on, a meaningful defendant unless you have access to some internal records.
Yeah, and with corporations, I mean, large, sophisticated corporations, I mean, they're designed deliberately to limit liability and limit accountability. So so it's challenging. So as an environmental lawyer, what's your favorite scene in the movie?
Honestly, I like the scenes in the record room. I mean, um, it's hard to imagine it went down exactly the way that it's depicted in the movie, but I think, we've all been there where you're just digging through records and trying to make sense of them, and then you see something and you're just like, holy shit. It's written in the language of bureaucraties. It looks like just like a figure, a page of numbers, but it's so meaningful, and it's like sometimes a smoking gun, and sometimes it's just sort of an indication to you of where you can dig further, or what's there. But for me, some of the rewarding moments of my career have been, looking at a particular document and suddenly realizing its import for a case. And so I really identified with her sort of dogged, digging through these just terrible records. And maybe in particular, I liked the one where she brought her kids and is getting sort of yelled at by the clerk, who's saying, like, you really need to get out of here. You've been here for way too long. And she tells him, these records are public records and I'm going to get at them. And that I've not had the experience. The records I've dealt with usually often come from secure locations, and you can't just like root around there yourself. But that just sort of instinct of like, this should be public, and if you have something to hide, then that's already a problem, and that's not how any of this should work. And so I am really concerned about the disappearance of record keeping. But I think this movie brings home how important those records are.
Anything else we should touch on, or
I don't know. Do you have any thoughts as a dad on whether or not the practice of law was compatible with the parenthood of young children? That's sort of a theme that runs through the domestic Erin Brockovich saga.
Yeah, I mean, well, there's a whole side plot which we even talk about with her boyfriend, or quasi boyfriend, Aaron Eckhart, who's taking care of the kids, but all the challenges that she has to do. I think there is this sort of personal aspect for her. Like, it does become very personal, and in the end, that's what sees her through to get justice. But there is sort of a question, I think, which the movie doesn't really, I think, get into, about like keeping the personal and the professional apart. I don't know. What were your thoughts?
I think that, the movie is not like a social realist piece or something, but especially in the beginning, it sort of shows how hard it is for her as like a, mom of three kids who's certainly facing some precarity. She's like on the edge of unpaid bills and everything else, to the point where she's excited to get into a car accident. So it kind of shows at times her struggles to have childcare, and then also some resentment from her kids for her not being available because she's, so doggedly pursuing this case. I feel like the practice of law can be very consuming, and it can demand a lot of people. I certainly think that a lot of the stuff I was able to do earlier in my career was in part because I could just dedicate so much time to work, just because I didn't have childcare responsibilities, I didn't have other responsibilities. With kids, I do find it gives me a different perspective on whether, how many client meetings, at night you're going to go to, or how many just, all-nighters you're going to pull, polishing something or researching something. So I thought, obviously she's dealing with it in this whole other more complex way of being, a single mother and in a very, patriarchal and backward sort of profession that, I hope has made improvements since she was experiencing in the 90s, but definitely, still has that. And as a person who's really struggling with precarity for a lot of the movie. But I thought it was nice to show those tensions because I've seen, both in my life and others, people struggling with the question of how do you balance, kids with high profile, very demanding litigation.
And just to balance the kids, and she's also, she's not a lawyer, and she's also, it just feels she's not really polished in the law firm way. I mean, that's sort of her secret power in some ways in terms of relating to people. But you see that interactions with the firm, and then especially with the other white shoe firm, and her interactions with the partner and both of the male partner and the female partner at the large firm, where she just seems like there's like kind of this cultural kind of clash, which is about, I think, class and gender.
Yeah, yeah, absolutely. Yeah, we didn't dig into that as much, but yeah, it's especially funny. Like I don't have the greatest grasp of the tort bar, but I've seen a few tort lawyers who I'm not aware of like what their actual class background is, but their presentation in the courtroom is often there's often such a contrast between the plaintiff's lawyer and the defendant's lawyer, often in the sense that the while the defendant's lawyer will work for a white shoe firm and the plaintiff's lawyer will not, the plaintiff's lawyer will often, try to like dress up and be like hyper professional and respectable, whereas the defendant's lawyer will come in with like the scuffed shoes and try to be much more like, a man of the people. So it was interesting here where it kind of had those dynamics, right? This like superstar mass tort plaintiff lawyer. So I guess he was also a defense lawyer since he was on the other side of the airline case, whatever that was that the lawyer alludes to. But here is on the plaintiff side is just like the most, brittle, just like an unpersonable suit. And Erin is like, this just avatar of human outrage and gumption.
Yeah, no, it sort of captures that. Yeah, I feel like it does a pretty good job capturing like some of those dynamics and subtleties, at least circa 2000, or when it was made. I mean, I think things have changed somewhat, not completely.
Yeah.
Well, Dror, it's been great to have you on the podcast. Thanks so much for coming on and talking about Erin Brockovich and a host of environmental and other issues.
It's been wonderful. Thanks so much for having me.